This episode is brought to you by Progressive Insurance. Whether you love true crime or comedy, celebrity interviews or news, you call the shots on what's in your podcast queue. And guess what? Now you can call them on your auto insurance too with the Name Your Price tool from Progressive. It works just the way it sounds. You tell Progressive how much you want to pay for car insurance, and they'll show you coverage options that fit your budget. Get your quote today at Progressive.com to join the over 28 million drivers who trust Progressive. Progressive Casualty Insurance Company and Affiliates. Price and coverage match limited by state law.
Welcome back to Come Back with a Warrant podcast. I'm Brandon Dinetz.
And I'm Monica Ishak. Before we kickstart this week's episode, this is your reminder that this podcast is not legal advice. It's real, unfiltered, and for entertainment purposes only. If you need to speak with a lawyer, call one. Or better yet, call us. Welcome back. Today, we are talking about all things consciousness of guilt, which means the guilty mind in a criminal case. So the state oftentimes obviously has to prove things beyond a reasonable doubt in a criminal case, whatever the charge elements are. And as a part of that, maybe the charged element might not include what we say as attorneys mens rea, right, which is the criminal intent to commit a crime. But that is always an element or a part of the crime that they have to prove. And so, you know, some charges have that associated with it, whether it's, you know, and that's what distinguishes, let's say, murder, right? Like first degree murder is the premeditated intent, and then second degree is a different level of intent, but it still has a criminal intent associated with it. So just generally, when it comes to the criminal intent for a charged crime, the state has to prove that that mens rea was present in order to be successful at the case. And so sometimes that's proven just with circumstantial evidence after the fact that the incident happened. And so that's when things get a little, I guess, like those are like the sexy parts of criminal cases, right? Like
Sure. When
you're driving and you throw the gun out the window or the drugs out the window, you know, after the police stopped you or whatever. Things like that.
Things that lead a prosecutor to be able to say, why would an innocent person do that? That's what we're talking about when we're talking about consciousness of guilt.
In conclusion?
It's the behavior and the actions after the crime occurs that prosecutors use to try to explain and show that this is the person that committed that crime. So just like Monica said, getting rid of the gun, getting rid of the drugs, those are easy examples of, the reason that somebody would do that is because that's showing a consciousness of guilt. It's showing that they know they are guilty. That's why they're taking certain actions. And these actions can extend beyond just the examples of throwing out a gun, throwing out drugs. These can extend to what somebody is searching online after an incident. And one of the things we're going to talk about in this episode is the Casey Anthony case, because in that case, the consciousness of guilt and trying to prove that circumstantially the actions that were taken by Casey Anthony after the death of her daughter should show that she is guilty. And we're going to talk about specifically what prosecutors tried to use in that case to show that consciousness of guilt. But everything that shows awareness of wrongdoing after the facts, after the case, after the crime has occurred, that's the type of stuff that we're talking about in this episode.
Well, maybe it's not necessarily an awareness, because I have seen in cases where actually the Casey Anthony case is a perfect example where the state tries to prove that this was an awareness of the crime. And but for instance, like you're acting nervous when you're talking to the police. They like to say that, you know, you're nervous during this interaction with the police because you knew that you did that crime and you were acting guilty. And that's literally the essence of consciousness of guilt. And so obviously it's not always successful. And that was my point. Because the Casey Anthony case literally hinged on all consciousness of guilt, like all of the major pieces of evidence, I should say, were based off of that. And that's why we're using that case as an example. But before we get there, we also want to talk about the situations and it's, I guess in my head, to me, I feel like she's guilty. So I forget that she was acquitted. But obviously, I think that's just a very sensitive case. I probably wouldn't have been the best juror for that case.
Probably not,
Yeah.
based on the fact that you just said you think she was guilty
Yeah,
off the jump.
No, obviously, like, they didn't have enough to prove it beyond a reasonable doubt, and her defense attorney did,
excellent
a
job,
really
right.
good job. But just like when babies are involved and it's like a mom and like 31 days pass and you don't report it, like, I don't know. There's just like a lot of things that I'm like, I don't like that. But does that mean she did it? So we're going to talk about all that.
It was not enough for the jury to find that she did.
Yeah, we're going to talk about all that. But so, anyways, there's also the situations where, people do lie to the police and they make statements to the police after the fact. And that also is another scenario where, the state will say you lied because you knew you did something wrong.
Right. And there's also, while we talk about often how the state uses these examples to try to prove its case, the state is also barred from using certain examples to try to prove this. So the state is not allowed to talk about someone invoking their right to silence or making a request for an attorney.
Yeah.
And that also extends to if somebody is searching on their computer for an attorney. That's something else that the state's not allowed to get into. So the certain behaviors that may also just from just normal perspective looking at it may seem to indicate guilt, like the idea of, somebody looking up a criminal defense attorney after something happened, that would make them seem guilty. That is not something that the state's allowed to touch upon because it would be infringing upon the Fifth or Sixth Amendment rights that we have.
You have these rights for a reason. So the state can't then come into court in front of the jury and be like, oh, well, look, this person chose to remain silent or chose to hire this lawyer, and as a result, they're guilty. They are not allowed to do that. And that is a big common misconception. Like, a lot of people do think that like, oh, like, they hired a lawyer, they're guilty. Like, they make that conclusion. And it's like crazy to me because to me as like an attorney, I'm like, that's their right.
Right.
Like, that's not allowed.
And judges will be very quick to instruct juries that that's not something that they could consider. They can't consider the person's choice to remain silent, and they can't consider the fact that they've chosen to hire a lawyer to represent them. That's not something that can be taken into account when trying to determine the guilt of that individual.
Yeah. The other example is people leaving the scene, too. I forgot about that one.
Right,
that's a huge one.
Sure. Fleeing the scene is always used as an example of consciousness of guilt. Running from the police.
Yeah, I was going to say, or like getting out of your car and running.
Right.
Oh my gosh. Those happen all the time. Like, that's the most common probably.
Yeah, it's up there.
I have talked about this before, the combo of like the DUS and the fleeing.
Well, driving under suspension, a misdemeanor quickly turns into a felony when you floor it away from the cops, and you get now the nice high speed fleeing and eluding.
Yeah.
That is, you're going to get a felony charge when you were only going to get the misdemeanor charge. And it certainly shows you some consciousness of guilt.
Yeah, exactly. If you want to try that case, the state can bring in the fact that your license was suspended. You knew that. You were guilty of it, and that's why you fled.
Yeah, it shows the reason why you did it.
And they're proving the DUS. At the same time, it's a 2-for-1 for them.
Correct.
They love to people just, I don't know, people are just so dumb. They love to do that. It just pisses me off. It's like, you really just escalated to a felony.
Well, yeah, you took it
because of that.
That's right. You took it to another level.
Yeah.
Literally.
So I guess moving on to talk about Casey Anthony, I was going to read the abstract. So I found this abstract from, I forget which university, and I'll tell you right now.
Before that, one other example that just came into my mind, a big one for consciousness of guilt, refusals.
Oh, yeah.
Refusing to give a breath sample, refusing to give a blood sample, refusing to do roadside exercises. The state loves to use those as examples of consciousness of guilt. The reason that they refused was because they knew what was going to be on the breath result. And
that is actually successful because when you're refusing, the officer tells you this is going to be used against you.
Exactly right. So it certainly is.
And it comes into court that they receive that information.
Right.
So like as a juror, if you're like sitting there watching, you're like, I mean, obviously if they don't exhibit signs of impairment and that's all they have, that's just like very weak circumstantial evidence. But
and that's where it comes in most common, and especially in a DUI case. You have a prosecutor that doesn't have a breath result, doesn't have a blood result, so they can't show scientifically that the person was impaired beyond the legal limit, but they can show that the person was exhibiting indicators that their normal faculties were impaired.
Exactly.
And that all comes down to the help of the consciousness of guilt
Exactly.
argument is huge there, because then you can look at the jury, and I've done this myself, and say, you know why they refused.
Yeah.
You know why they didn't do exercises, because they knew they wouldn't pass them, or they.
We had a case like that together.
Of course. So
It was a hung jury.
Well, either way, the jury made the call.
But to your point, I think that consciousness of guilt is a good supplemental piece of evidence, but I don't think that, and this is going to tie in heavily into the Casey Anthony case, is that it's not the only way the state should approach their case, I think, because if that's all you got, then good luck proving that this person did it beyond a reasonable doubt.
True. But think about how, specifically using the Casey Anthony case, how high profile that situation was. And if the state attorney's office chose to do nothing in that situation, there would have been complete public outcry.
I mean, there was.
Right.
I mean, this is a big case, and if you don't know it, I'm going to tell you about it right now because I have this
let's
abstract.
talk about it.
Yeah. So this is
you back to 2008.
Oh my God, we looked it up. I was like, oh my God, that's crazy.
I can't believe it was that long
Almost
ago.
2 decades ago.
Yeah.
I remember watching it on TV, literally, and I didn't even think I was going to be a lawyer, criminal defense lawyer at the time. So, Fort Hays State University Criminal Justice Department issued I don't know, a scholarly letter on this or whatever. What am I saying? A letter?
Well, they've provided
it's a book.
Okay.
Whatever.
Go for it.
Whatever volume, whatever.
Some sort of journal.
Yes, exactly. I was not on that when I was in law school, by the way.
Yeah, well, that's okay.
I was on all things trial. Anyways, so Casey Anthony is the mother of Kaylee Anthony, who went missing in 2008. Her mother called the police to report her missing 31 days after her last sighting. During the investigation, Anthony lied to police on multiple occasions, which led them to arrest her for the murder of her daughter. Anthony was then charged with the first-degree murder along with aggravated child abuse and aggravated manslaughter of a child. Kaylee's body was found shortly after the missing persons report, wrapped in a blanket near the Anthony's home. Florida wanted the death penalty in the case against Casey Anthony with mostly circumstantial evidence. The defense wanted to show the conspiracies that led up to the case. Casey ended up being sentenced to 4 misdemeanor counts of lying to the police and multiple fines that she had to pay for the police investigation. So she was ultimately acquitted of the most serious charges, which was the murder of her daughter.
Correct.
And that's, why it's such a, big deal, because of some of the facts I just read, hearing that you are reporting your child missing 31 days after you last saw them. And then we're going to talk about how she lied because she was convicted of lying to the police. Well, she did some dumb, and she made some dumb choices, and the lies that she told that we're going to get into it it was not smart. She should have been convicted for lying to the police. That made sense. She probably should have been convicted for killing her kid as well, but that's neither here nor there at this point. Yeah, exactly. So the internet search that was like kind of a big deal in the trial was this chloroform. And so, we were talking about online searches, and like, I guess the most common online search you would think of is like how long like GSR would last, or, gunshot residue and stuff like that. But in this situation, there was chloroform involved in the like physical forensic evidence in this case. And so there was a search that appeared on the family computer, and they argued that that was a part of her intent and awareness of the crime happening, because I think they found that the blanket that she was wrapped in had chloroform on it or something like that.
So for those of you that don't know, chloroform is a knockout chemical. It's a chemical that's used to incapacitate another individual and to basically render somebody unconscious. And there's also discussions where it can be used to, I think, speed up the rate of decomposition of a body. So that's another area where that came up in the case. But the ultimate question is, why would somebody be searching that on their computer? Then you take into account that the daughter was likely incapacitated by this substance, and this substance was found on or around the daughter's body. Yeah. So the question easily becomes, well, if she was looking at why would she be looking that up after the fact and there really is no other reason other than to assess what the length of the effects are, or how fast it could be used to decompose a body, or asking any of those questions would lead somebody to believe that they had some involvement in this person's, at minimum, incapacitation.
Yeah, well, they try to combine that with the physical evidence that they found in the trunk of the car, because I believe that in the trunk of the car they had found like evidence of
the trunk
body.
of her car.
Yes,
right.
Of the body, like a decomposed body was once there, I believe, and there was like trash bags in there that had a stain. There was like a stain in the trunk. Like there was a lot of physical evidence in the trunk of that car, and they were trying to tie that with the chloroform search as well to show that, like, that's what they were trying to supplement the chloroform search with, to show that she was the one that did it. And so that's where the experts would come in and testify. And like, that's the thing. It's like these cases, you need a lot of, experts to be able to explain to a jury what chloroform is, the effect it would have on, like, I'm sure they had a doctor testify the effect of chloroform on the human body, what its intent is for, like if it's,
it's not just something you pick up at the CVS.
And, at that point, I don't think you can have an expert testify on like the actual search online, but they can have whoever extracted that information testify that was on the family computer. And that's the other thing that the defense pointed to. It was that this was a shared computer between family members at the family home that Casey Anthony and her two parents and their daughter lived at, or her daughter lived at. And so those are, points to show that maybe it wasn't Casey that did that. It could have been one of her parents, or it could have been someone else that had access to that computer. Because there's really no way to prove who made that search on the computer. Like, you can only confirm that this was made on this computer, but you can't prove that it was Casey.
The person that did
yeah,
it.
exactly.
Yeah.
So it wasn't like it was this private computer that was in her room hidden away, and it was like her login and all these things. Like, those are different facts that change the scenario, and that's why it's important to remember. And I'm partly saying this because of me, because I was like, oh, I'm surprised because like, I do have to remember, like, those facts matter. Like, the fact that this was a shared computer, like the car was parked in their family garage as well. There are a lot of different ways that the defense was able to say that was not Casey Anthony, or could not, maybe it was not. And if you believe that maybe it was not, then the state has not met their burden.
Correct. And it's not beyond a reasonable doubt.
So, and that's just like one of the pieces of evidence. There's also, if you're familiar with this case, that the duct tape was found over Kaylee's mouth when they found her body, or the remains of her body was, proof or further proof of the chloroform, when they were trying to say that she was probably, I was going to say taken out, by the chloroform. So, they were trying to show that, like, that only could have, that basically the chloroform search makes sense alongside with the physical evidence that we found on Kaylee and in the trunk of this car.
It shows a level of planning and awareness, and it shows certainly whoever was searching after the fact has some awareness. And why would they be searching about that fact and then specifically have somebody tied and related to them be incapacitated by that substance, and someone in that house is looking it up?
Yeah.
I mean, it's a hell of a defense to say, it's a shared computer. So likely if it wasn't Casey Anthony that did it, then it could have been one of her parents that killed her daughter. I mean, like, you're kind of saying, oh, maybe it wasn't her, but it was one of the other people living in that house, is kind of what you're saying.
But she's the one on trial.
Right. That's
so
right.
Like, as uncomfortable, I think, as that may make anybody feel, it is the reality of the situation that this person should not be convicted based on the actions of another person, even if they're remotely connected or related to this person, True. But it is uncomfortable to, it sounds like you would be okay with that any caregiver would, like, do that to a child. You know what I mean? So I think, like, just saying that as a defense attorney, and I think that's why people probably don't like us as much as,
Well, it's
because we do have to make arguments like this.
Yeah, and these cases are few and far between, but you do have to argue what you can within the confines of the law, and that's exactly what her attorney did in this case.
Yeah, and sometimes it's uncomfortable. Like sometimes it's not.
Yeah, and that's
the best,
I mean that's
most glamorous argument.
Right, that's true.
It's important to note that this chloroform search also like occurred before the murder or her,
which is why I made the comment that I think it shows that the argument from the state is that it shows a level of planning and awareness, because it shows that this was, how the killer was going to take the steps that they took, and specifically with what. That's what the state is able to point out. But again, they can't say for sure that it's this person that did it.
Yeah.
Because there's other people living in the house.
Yeah. And, like going to the Universal lie about Universal Studios.
Right. Exactly.
So like that was also like that is more, I guess, like consciousness of guilt. Cause like the pre-search is not really.
Right.
But it is circumstantial evidence.
It's circumstantial evidence for sure. But then the lies that she came up with to try to cover up certain things and where she was and what she did at certain times. And I do think
they make her look guilty.
They do make her look guilty.
Because she literally lied about working at Universal Studios. I thought it was Disney, but it was Universal. And she she
took them to Universal,
police,
and then when they got there and they got to a certain point in Universal, she was like, yeah, never mind.
She's like, I lied after like this long, fleshed out lie. Like, you just put in all this energy to show the police that, you were working on this day and there was no way you could have been the one to have killed your daughter. And you're like doing like, so like basically the state is trying to say like, if you were innocent, you wouldn't be making up this lie.
Right. And she went into full detail about the job, and she went into detail about the park, and she up to the point where she physically took the officers into the park.
Yeah. I don't think lying to the police is always an indicator of being guilty, but I think that the extent that she took it to makes her look very guilty.
Yeah.
Because I have seen scenarios where people just like, they just want to be done, and they just we've heard of the scenarios where somebody's being interrogated for so many hours that they just decide they're going to say whatever they need to say to get out of the little interrogation room, and that very well could be admitting to an offense that they never committed. Exactly.
Right.
And so people do lie to the police when they're innocent, and so like the idea or the argument that this person lied to the police, therefore they are guilty, is not always a successful argument. But I think because of this facts surrounding this situation, and that's why it's so important to pay attention to certain facts that happen in cases, is that they changed the scenario. And I think that would have I don't know. I don't want to say it would have been successful with me, but that is definitely something for me that I would be like, yeah, that is so sketchy.
Well, an innocent person wouldn't need to fabricate a job.
Take them all the way
details
into
of having this fake job.
Yeah.
To cover up where they were at a time where.
And that's your concern.
Right.
Exactly. Like that's your concern over the fact that your daughter is missing.
Right.
Like, so that's the other thing. And I was thinking about this because, our notes say behavioral evidence. And I'm like, well, like technically I haven't really seen, I don't think this is legal, but to have somebody come and testify that like, you look to the left and so you're lying. And like, if you're doing this, that you're not being truthful.
Like a body language expert?
Yeah.
I think there's times where body language experts are used in cases. And I think that if this was a situation where there was a confession and the allegation by the defense was that this was a coerced confession or that there was something wrong with the confession,
the defense
then I can see either the defense bringing in a body language expert to show, or even the state to rebut it at that point. I could see them using. So yeah, I absolutely could see a body language expert or somebody coming in to say, yeah, look at the way that this person is reacting to questioning. Yeah. They're indicator of either a liar or somebody that is telling the truth or somebody that's stressed out because they're in the situation of being interrogated. I think there's ways to get that out. Yeah,
I don't love that. I'm not going to lie to you. Well, I mean, I would love it if it were to be beneficial to my client, but I would love it if the state were to do that. I'd be like, no. So basically, like the point of all of these different facts and how they come together is that the state really used these to stack them together in order to prove that she was the one who, or try to prove that she was the one who committed
that
the
she
murder.
lied to the police, that she looked up this information, that all of these pieces,
plus
that
the
if you put them
forensics
together, if you put these pieces together, they should lead someone to believe that that's the person that, you know, killed the girl. But that doesn't, you know, none of that information actually proves that she did anything. It doesn't prove that she's the one that, you know, it's not like her prints or you know, a receipt for her buying chloroform. I mean, there's a lot of things that are missing.
Yeah, that's the problem.
And those things that are missing were enough for a jury to come back and say that she's not.
Yeah.
That she didn't. Is not guilty.
Yeah. So like so for me, it's like, yeah, I see this. Like, I do believe that it was sketchy, and I do believe she knows more than what she made it seem like she didn't know. But do we have enough to say that she did this? And the answer is no. Like, and that's why the jury acquitted her. And so, like, consciousness of guilt at the end of the day is interpretive and like interpretive. Yeah. I'm like, am I saying that right?
Yeah, you are.
And like, it's subjective is what I'm trying to say. Like, it's really in the eye of the person who's receiving that information. Just like I just said, you know, like, I think Casey Anthony in that situation seems super guilty for going all that way to lie, but I don't think that's the scenario every time. And I think that always comes down to jury selection, like knowing your jury and talking to them, like, is so important, because I think with a different jury, maybe in a different area too, like maybe not in Florida.
Maybe not where she was in right outside
like
of Orlando.
In Orlando,
right?
yeah. That is I think a more like generally more open
place.
Yeah. Exactly. That makes a difference. So versus like if you're in the middle of nowhere and, you know, everybody knows everybody.
The Parkland shooting, if that was not in Broward County, if that was in Martin County, that guy would be dead.
Yeah.
Like 100%.
Yeah. I agree with that.
So this case happening in a different county, you know, you put this in Port St. Lucie and you put a Port St. Lucie jury in front of these facts.
Makes a difference.
It could be a completely different scenario.
Yeah. And so like ultimately, like what the defense had to do here was remind the jurors that, you know, like just because you're suspicious, like, yeah, it could be sketchy, but just because you think it's sketchy, it doesn't mean that this person committed murder beyond a reasonable doubt. And so, and that's like, it's such a big deal that this person is staying trial, because like everybody knows that she was facing potentially the death penalty and then life imprisonment if she's going to be charged with murder. Like other charges, you can't figure it out, right? Like in the in-betweens, like as a juror, you wouldn't know, and
you're not told as a juror when a case, you know, when there's a misdemeanor DUI case, the jury's not instructed as to what the possible punishments are going to be.
Exactly.
But a juror knows walking into a homicide trial that, this person's looking at
their
life or potentially death.
Yeah.
That's known.
Yeah. And so in those scenarios, as a defense attorney, you have to kind of break up the pieces of evidence and say, like, make innocent explanations of each thing. And, you know, she was nervous and that's why she went down this path and she got on the stand and testified to that. And like, there's so many different ways to break up these pieces of evidence instead, because the state, you know, like we were saying, they're trying to combine it and show that this is intent, awareness, a guilty mind. That's why all of this is important for you to see it together. It's not just one piece of the puzzle. It's the whole thing. And that's what makes the picture. And the defense has to break it apart, and they did successfully. They have to
break down that narrative, and they have to take it apart and show each piece. You know, the computer could be searched by somebody else in the house. She could lie about her job, but have different reasons to lie about her job. But whatever the argument was about the lying about the job probably wasn't that successful, because she ultimately was convicted of that.
Exactly.
So, but this is not the type of situation where it's like, oh, the jury split the baby, which is really inappropriate to say in this case. But,
oh my gosh.
This is not that type of example.
And when we say that as attorneys,
it's not right. It's what I mean is that the jury said, oh, well, she probably did something, so let's convict her of something.
Yeah.
Like these were really, really, really lessers compared to the homicide charge.
Yeah. Like she was being charged with aggravated child abuse and she didn't get convicted of that.
No.
Or child neglect. She didn't know where her kid was for
with
30
a 31 day. Right. I mean, there's just there's a lot that,
Listen, her attorney did a great job. That's all we're going to say. He came to my law school when I was in law school and talked to us about his defense in that case and other high profile cases. And it was like really cool to meet him and see that, because like I'm saying, like we said, it was in 2008, like seeing that on TV and then going to law school and then being able to actually talk to the attorney. Like, it's just like kind of like a crazy surreal moment. And, it's a really big case. So
yeah, and it's huge, and people in Florida still talk about that case.
Literally till this day.
Yeah. And whenever you had made a comment, but whenever she surfaces around anywhere, the news like always says, they'll spot her.
She was in public.
There's the Florida Man Instagram account. Like, I think he mentions Casey Anthony like once a month.
Yeah,
I mean,
literally.
Like that all the time. That still comes up. So we're almost 2 decades removed from that, and it's like it's still a case that had enough attention and I think because of the verdict, it keeps the attention because she was found not guilty.
Yeah.
That keeps people, and people are very opinionated about that case. It's funny. I have not heard.
Opinions.
We're defense attorneys, and I have not heard somebody that people can articulate why she was found not guilty, and I understand that because I'm a lawyer. And we do this. But I have not found anybody that thinks that she was not guilty. Yeah, or like anybody she wasn't involved in any way. Oh, yeah, she definitely did that.
It's kind of like the OJ case.
That's very much like the OJ case.
Like, it's literally the OJ case of our time.
Except, yeah.
I mean, she wasn't an NFL player.
But the difference, there's some significant differences just because the way that the climate was and at the time, there are big differences, but with how high profile that case was,
it was such a big deal. Like, I just the fact that we were talking about that it's in 2008 is mind blowing. I feel very old because in 2008 I was not even, you know what? I'm not going to tell you guys my age. I'm like, let's move on from this. It's like, times have changed.
Yeah. It's funny to hear that then you didn't know that you wanted to do this.
Yeah.
You had no idea then.
I was so interested in the case.
Yeah, of course. Yeah.
I don't know. Maybe it was like, the thing is, I was always that kid that was told that I was going to be a lawyer. Because I was always like, just like yapping and arguing back. I always had a response. I was like very much so talkative. That was the main thing I got in trouble in school for. So.
You hear parents say that, oh, you're really good at arguing. You'll be a great lawyer one day.
Yeah. So
some of those people did turn out to be great lawyers. Some of them are not.
Yeah.
Some of them are in jail.
Yeah, that is true. Because they were running their mouths.
They ran their mouths too much.
Yes.
You got to know when to turn it off.
Literally. Well, listen, some people become lawyers and then they go to jail for that reason.
That's right. We talked about that too. We've talked about that issue also.
That is so funny. So, anyways, consciousness of guilt is a very important part of, I think, criminal cases in general. Yeah. You don't really know the term consciousness of guilt, hence my yapping in the beginning explaining what it was if you're just like a lay person or someone who doesn't really go into the courtroom often. But that certain facts can come into a case, such as a search or disposing a gun outside the window. I had a murder trial that, I think I told you about this, where he was accused of, it was a self-defense case. Well, we were arguing a self-defense, and he disposed the gun on his way out from wherever he was, and they ended up finding it later, and he had to he testified, and he was saying it was self-defense, but he had to admit to that because otherwise it would show the consciousness. He had to say,
does show a consciousness.
It does,
guilt.
But he explained it because he was like, I was nervous, and I didn't know what happened to that person, and I was at the time afraid, hence why I used the gun, and I got rid of it. And I think jurors respect that way more when they hear it's not ideal. I don't think they'll good job, you know, but I think versus sitting at the defense table and not saying anything, and they're hearing this incriminating evidence that this was found on the side of the road and it was ditched, or they have a video of you ditching the gun or a witness or whatever the case is, and they end up seeing that you're hiding something versus getting on the stand and saying,
Yeah, but this argument doesn't work like people think it does, because you see, and I saw this as a prosecutor, taking the example of a DUI where there's a refusal. So many people have been told to refuse to give a breath if you're ever asked, that there are jurors, and
they think it's their right
here on this, that they say, oh, well, the people refuse all the time because they just know that they just shouldn't give a sample.
Yeah.
So the argument doesn't always work. And certainly in the Casey Anthony case, that consciousness of guilt argument is oftentimes not enough.
Yeah.
And I think some jurors are wise to that and understand that. But,
nice.
Which is nice, which is helpful. But, other times this is what the prosecutors rely on to try to prove guilt.
Yeah.
And it's successful in certain circumstances. But in others, it's really not. It does come down to your jury in the most part, I would say.
And how the story fits together as well, because jurors, like, if you are in law school or you're going to try a case, like, I think that almost every trial program or good trial program explains to future litigators that you need to be able to be good at telling a story. Like, you're presenting a story, whether you're a prosecutor or defense attorney, like, you have to present a different set of facts. And so, like, when you do that, if you're doing that with only like circumstantial evidence, consciousness of guilt evidence, you're not really presenting a story of how this was executed and how it happened. You're just saying, this looks like she's guilty, but that's not enough here, because you're convicting someone for the rest of their life. So like, at the end of it, like you were saying, it doesn't really tell you exactly what happened.
But the one thing, and this is something that as a prosecutor and as a defense attorney, you can't choose the facts.
No. So
you can only go with what you can go with.
Yeah.
And that's,
you got to work with what you got.
That's why you lose cases.
Yeah.
And that's why you win cases. You can only go with what you can go with. So as a prosecutor, you make the best that you can.
Yeah. With what you got.
Right.
Yeah.
I was told by a defense attorney after a trial once that I did an excellent job making chicken salad out of chicken shit. And that stuck with me forever, because you do what you can with the facts that you have in front of you. And
I mean, you do that on the defense side too. So
that's exactly right.
A lot.
That's exactly right.
Sometimes your clients want to go to trial and you're like, this is not a good idea, but let's go. And we'll make chicken soup out of chicken shit.
There you go. Different dishes.
Well, all that to say, we hope to kick this state's ass in the next consciousness of guilt trial we have.
I agree with you.
All right. Well, if you liked listening to the podcast, make sure you like, comment, and subscribe. We are on all platforms. Come back with warrant.pod. Give us a 5-star review and subscribe to our weekly newsletter. And if you didn't like listening to us,
come back with a warrant.
Are you ready to finally make that dream a reality? Maybe it's updating your kitchen, paying down high-interest credit cards, or covering tuition. Your home is more than where you live. It's also your most powerful asset. At Unlock, we make it simple to turn equity into options. With a home equity agreement, you can access cash today without taking on another monthly payment. Imagine the freedom to invest in your home, reduce financial stress, or finally start that big project you've been putting off. It's your home. It's your future. Unlock it today. Visit unlock.com to learn more about a home equity agreement. That's unlock.com to learn more.
Terms and conditions apply. Not all homeowners will qualify. Not available in all states. Actor Portrayal. Home equity agreements are offered by Unlock Home Equity Solutions, Inc. In certain states, NMLS number 2657081. Visit www.consumeraccess.org for more info.